Now we take up our last topic in the first section of this course: title, risk of loss, and insurable interest. These are three concepts that are going to be needed to understand the sales process. Now, for years, the concept of title played the most important role in commerce. Title, of course, is the formal right of ownership. Title is a recognition as to who owns the thing, who owns the item. Now, the UCC attempted to separate the question of title from the sale of goods. That title is just one more aspect to include when deciding relations between a buyer and a seller. That equally important is the risk of loss. So title remains important under the UCC, but it has lost some of its most important status. In this lecture, we're going to study three concepts: title, risk of loss, and insurable interest. And they all are sort of interrelated. But after this lecture, you should be able to answer the following question: what is the concept of title? How does title pass? What is the concept of risk of loss? What is insurable interest? And what are the different kinds of sales contracts, and how does each type affect title passing, risk of loss, and insurable interest? Now, before we can understand title, we have to understand a concept of identification. Now, what is identification? Well, identification requires two things. For title to pass from the seller to the buyer, the goods must be distinguished from similar goods. We must identify the goods that are going to be subject to the sale. This is the first step in the passing of title. Title cannot pass until the goods are distinguished from other similar goods. Once identification gets made, identification gives to a buyer a right to obtain insurance on goods and to recover from third parties who damage the goods. Two items must be met then before any interest in goods can be passed from the seller to the buyer. The goods must be in existence, and the goods must be identified. The presence of these two items will allow for the transfer of title from the seller to the buyer. The goods in existence and the goods being identified. And again, identification is a designation of goods as the subject matter of a sales or a lease contract. So for passage of title, goods have to be identified in a way that will distinguish them from similar goods. Identification could be a matter of designating specific items, oftentimes by serial number. But sometimes when goods exist in a larger mass, say you have sales of 1,000 case lots, for instance, identification can only be made by actually physically separating goods from the mass. Now, once the goods are in existence, the parties can agree as to when identification takes place. Because identification is important because it gives to a buyer the right to obtain insurance on goods and to recover from any third parties who damage the goods. Identification, if it's not specified in the contract, there are additional rules that apply, oftentimes involving specific things like crops or animals. But generally, goods are identified when the goods are marked, shipped, or otherwise designated by the seller as the goods that will pass under the contract. And the seller can do this physically, or it can do it on a spreadsheet. So identification is really a matter of designating specific items. Now, the point at which identification occurs varies depending on the nature of the good. Existing goods. If the contract calls for the sale or lease of goods that already exist in their final form, then identification is going to occur at the time the contract is made. So, if a sale involves specific goods that are already in existence, identification is going to happen when the contract is made. Now, future goods, if the contract calls for the sale of goods that have yet to be completed in accordance with the contract, identification will occur when the goods are shipped, marked, or otherwise designated by the seller for delivery to the buyer. So future goods are identified at the time when the goods are shipped, marked, or designated by the seller, not at the time of the contract as with existing goods. And the third type of good is fungible goods. Goods that are fungible are alike by physical nature. Things like grains of wheat or barrels of oil. Identification of these goods occurs when the goods are shipped, marked, or otherwise designated by the seller for delivery to the buyer. Now, when we talk about title, there are actually three types of title that we are interested in. And remember, title is a formal right of ownership. And the first is good title. Good title is acquired from someone who owns the goods free and clear of any encumbrances or liens. So if you have good title, you can acquire that from someone else who has good title. Void title is a title that cannot be passed from the seller to the buyer, that does not allow ownership of the goods to pass. And void title results when acquiring stolen goods. Stolen goods have a void title, and that means that the owner of the goods, the true owner of the goods, can always recover the goods because it was impossible to transfer the ownership of the goods because of the void title. More complicated is the notion of voidable title. A voidable title occurs in situations in which the contract between the original parties would be void, but a third party has purchased the goods. The goods have already been sold to a third party. That means that while there is a cause of action from between the seller and the buyer originally, the third party buyer gets to acquire the goods. We'll talk more about voidable title in a second. Now, a seller has voidable title if the goods that she's selling were obtained by fraud or deceit. If you sell a vehicle claiming that it is a super rare vehicle and worth thousands of dollars, and it turns out to be worth much less than that, that is the proceeds that you obtain are going to be obtained by fraud or deceit. If you pay for it with a hot check, a dishonored check, if the goods are purchased from a minor or purchased on credit when the seller was insolvent. The important thing to remember about voidable title, however, is that a third-party purchaser can acquire good title while even though the goods were obtained by fraud or deceit or a hot check. Now, imperfect title creates problems for those who attempt to sell or lease. A seller who has void title cannot transfer good title. So if a buyer unknowingly purchases goods from a seller who is not the actual owner of the goods, the buyer's title to the goods is void in the same manner as the seller's title was before the sale. So a seller who has void title cannot transfer good title. However, a seller whose title is voidable has the power to transfer valid title to a good faith purchaser. As a general rule, if the third party purchaser makes a good faith purchase for value, meaning there's been some money paid for the purchase, that third party purchaser gets good title, not void or voidable title. So the good faith purchaser, what we often call the bona fide purchaser, the BFP, and we'll talk a lot about this when we get to negotiable instruments, actually acquires good title from a seller who did not have good title. So the good faith purchaser actually winds up with more interest in the goods than the party who sold the goods to it. Now, entrusting goods to a merchant, when you entrust goods to a merchant who deals in goods of that kind, gives the merchant the power to transfer all of the entrustor's rights to a buyer as long as it is in the ordinary course of the merchant's business. If an owner entrusts the possession of goods to a merchant, the merchant can transfer all rights in the goods to a buyer in the ordinary course of business. Meaning, if you are going to entrust goods to a merchant, understand that merchant has the right now to transfer the rights in that. Risk of loss is a concept that involves whether the buyer or the seller bears the risk of loss when something goes wrong. If the goods are damaged in transit, this question of who is responsible for those goods, for the loss of those goods, who bears that burden, is going to become very important. Now, risk of loss may follow title. That risk of loss may pass when title passes, but it does not always do so. It will depend on the type of contract at issue. Now, we've talked about in our very first lecture about how parties can allocate risk of loss. In every contract involving the sale of goods, this arises. Now, by agreement, parties can control when the risk of loss passes from the seller to a buyer. Risk of loss is a concept that states whether the buyer or seller bears the burden when something goes wrong, when there is some damage to goods during the course of the sale. And if the contract does not specify when risk passes, then we turn to the UCC. Remember, the UCC is the gap filler. It provides the clauses that will apply if the buyer and the seller don't include those clauses in their contract. Before we go on to finish risk of loss, let's talk about an insurable interest. Remember, a property interest in sold goods is an insurable interest when it is sufficiently substantial to permit a party to insure against damage to the goods identified in the sales contract. You probably never thought about this much, but can you buy insurance on your neighbor's vehicle? If you know that neighbor is about to go drive negligently or dangerously, can you then go buy insurance on your neighbor's vehicle? Well, probably not, unless an insurable interest exists. That means you have some interest in the goods that is substantial enough to permit a party to insure against loss to the goods. Now, parties to contracts usually will obtain insurance on the goods during this time when the goods are in transit. One party or the other, the seller or the buyer, will obtain insurance on the goods. Insurable interest refers to the right to insure goods against any risk exposure. An insurable interest is a sufficiently substantial property interest in sold or leased goods. Now, buyer has an insurable interest when the goods are identified in the contract. When the goods are identified, the buyer can now insure the goods even though the goods remain in the possession of the seller. The buyer has a right to insure against loss to the goods. A seller has an insurable interest as long as she retains title to the goods. As long as the seller has title to the goods, the seller has an insurable interest, even if the goods are not in the seller's possession. Goods could be in transit, and as long as the seller has title to the goods, she can insure against their loss. Now, determining the point at which title and risk of loss can depend on the contract. The type of contract. Now, the UCC provides 4 different scenarios for the sale of goods. 4 different things that could happen in the sale of goods. And the first is a simple delivery contract. This contract is formed when the buyer and the seller execute an agreement and the buyer simply leaves with the goods. You go to Lowe's, you pick out a new ceiling fan, you take it away. That's a simple delivery contract. The common carrier delivery contract is the one we're most concerned about for this course. This contract occurs when the goods are delivered to the buyer via a common carrier. A common carrier is an independent third party that carries goods from the seller to the buyer, such as a trucking line. Goods and bailment contract. This type of contract occurs when the purchased goods are in storage under the control of a third party, such as a warehouse. Oftentimes, goods will be stored in a warehouse not belonging to the seller. And the seller can sell the goods, retain title, even when the goods are in the possession of this third party. And finally, a conditional sales contract occurs when the sale itself is contingent on the existence of some condition, such as approval of the goods. Let's talk about each of these contracts in turn. We'll start with a simple delivery contract. Again, this is formed when a buyer and seller execute an agreement and the buyer leaves with the goods. In this case, title transfers from the seller to the buyer when the contract is executed. Remember, this is when identification takes place. If the seller is a merchant, the risk of loss transfers to the buyer on delivery of goods to the buyer. Once the buyer has the goods in its possession, the risk of loss will transfer if it is a merchant. If the seller is not a merchant, then risk of loss transfers when goods are made available. And we call this tender of delivery, when you make the goods available for someone to pick up. So if the seller is a non-merchant, this is a person who's not dealing in goods of the kind, risk of loss will occur at an earlier point than if the seller is a merchant. If the seller is a merchant, there must be delivery of the goods before risk of loss transfers. If the seller is not a merchant, risk of loss transfers when the goods are made available. A buyer has an insurable interest on receiving title to the goods, and again, title transfers to the buyer when the contract is executed. A common carrier delivery involves transported goods, and this exists when a buyer and seller execute a contract and the seller subsequently places the goods into the hands of a common carrier. And the common carrier is an independent contractor, like a trucking line. It has no ongoing relationship with either the seller or the buyer. Neither the seller or the buyer will have ownership interest in this common carrier. There are two different types of common carrier delivery contract. There is a shipment contract and a destination contract. And we'll talk about those in a little bit more detail. A shipment contract requires the seller to ship the goods to the buyer via a common carrier. And in a shipment contract simply requires the seller to ship the goods. Title transfers to the buyer at the time and place of shipment, when the goods are placed in the hands of the first carrier. Similarly, risk of loss will transfer when the goods are placed in the hands of the first carrier. So when you look at this problem on your test involving the transfer of title or risk of loss, you'll want to determine if there is a shipment contract or not. The shipment contract simply requires the seller to ship the goods to the buyer by way of a common carrier. In a shipment contract, the buyer bears the risk of loss while the goods are in transit. Risk of loss. What are those losses? A truck could get into an accident. A truck could spring a leak and the interior contents be damaged. There could be faulty loading. There could be faulty storing of the goods while they are in transit. Anything happens to those goods while they're in the transit in a shipment contract, assuming no agreement between the parties, the buyer is going to bear the risk of loss. Now, a destination contract is a contract in which the seller agrees to deliver the goods to some designated place. A destination contract requires that the seller deliver the goods to the place stipulated in the contract. In a destination contract, title does not pass until the goods are tendered for delivery at the place stipulated in the contract, the stipulated destination. So the seller is going to bear the risk of loss until the seller delivers goods to the destination that is described in the contract. So in a destination contract, any of those risks that we talked about, damage to the vehicle, damage from faulty loading, damage from faulty storage while in transit, any of those things that happen, the seller is going to bear the risk of loss. Finally, a goods and bailment contract. Now, this is a bailee is a party who, through some document of title, acknowledges possession of the goods so long as the seller has not yet transferred them. If a bailee holds goods for a seller and the goods are going to be delivered without being moved, risk is going to pass when the buyer receives what's called a negotiable document of title. So in a storage situation, a goods and bailment, like with a warehouse, the seller cannot transfer physical possession because the seller doesn't have physical possession, although the seller has title. The seller will have some document that indicates ownership, either an actual title document or a warehouse receipt. When the seller deposits the goods into the warehouse will provide a receipt, and that receipt becomes evidence of ownership. It's just as if a formal title was filed with the bank. Rules regarding passage of title, risk of loss, and insurable interest vary depending on whether the seller has negotiable title. Now, we'll talk about negotiable title in the negotiable instrument session, so don't worry about it too much at this point. We'll spend a lot of time talking about negotiability when we get to the third part of the course. Conditional sales are those that are conditioned on either the buyer's approval or the resale of goods. When it is a sale on approval, in this contract, the seller allows the buyer to take possession of the goods before the buyer decides whether to complete the purchase. And the law states, the UCC states, that until the buyer accepts, both title and risk of loss remain with the seller until the point at which the buyer notifies the seller of approval. The next type of conditional sales contract is called a sale or return. It occurs when the seller and the buyer agree that the buyer may return the goods at a later time. This happens when a buyer is unsure if a good will actually sell, and so purchases it from the manufacturer under the condition that it may return any unsold goods at a later time. When the buyer receives possession of the goods in a sale or return situation, the buyer title and risk of loss both pass to the buyer. The buyer takes on the risk of loss as well as receives title. However, because the buyer retains the option to return some or all of the goods at the buyer's expense and risk of loss, the risk of loss and title will revert to the seller once they are back in the possession of the seller. A buyer will have an insurable interest in this case once the goods are identified in the contract. Finally, a consignment sale, when the consignee has the goods, if you leave the goods on assignment, say with a used car dealer, will take your vehicle on consignment. While the consignee has the goods, he or she has title to them. They actually have title to the goods. That means they have the power to transfer the goods to a good faith purchaser. What about risk of loss when a party has breached a contract, either the seller or buyer? Well, risk of loss will vary depending on which party breached the contract. Say that a seller breached by failing to deliver non-conforming goods. In this case, the buyer may accept the non-conforming goods as is, or could reject the goods. Risk of loss in this case remains with the seller until the buyer accepts the goods or until deficiencies are corrected. If the goods are so non-conforming that a buyer rejects them, risk of loss does not pass until the defects are cured. So risk of loss remains with the seller until the buyer accepts the goods or until the deficiency in the goods are corrected. If the seller breaches but the buyer accepts the non-conforming goods despite their defects, risk of loss passes. If a buyer accepts and then later discovers the defect, the buyer can revoke its acceptance and thereby pass the risk of loss back to the seller. Buyer breach. Buyer refuses to accept conforming goods, goods later lost or damaged. In this case, risk of loss depends on the type of the contract between the buyer and the seller. When a buyer breaches a contract for the sale of goods, the risk of loss immediately shifts to the buyer, but only if the seller has already identified the goods. And the buyer will only bear the risk of loss for a commercially reasonable time. The buyer is only liable to the extent that the seller's insurance doesn't cover the loss. Now, in the absence of any contractual language, the risk of loss is going to shift to the buyer, but the buyer is only going to bear that risk of loss for a reasonable time. So, in conclusion, what did we learn today? Understanding title starts with understanding identification, the concept of identification. Commercial transactions require knowing when an insurable interest exists, and determining the point at which title and risk of loss pass depend upon the contract. That's all. Thanks for listening.